I really do owe my career to my mother. She was the toughest boss I ever had. They had never had a female bench officer in that part of the county. They'd never had anybody with a Latino or Hispanic surname. The hardest has to be family law, that assignment, because there's so little resources put to it. And that's been the case all my career. You have to let go of whatever is going on with the sibling or the step parent or whoever it is on the other side that you disagree with. If you love that parent, you want their last years not to feel like they're caught in the crossfire. Sometimes it's too late, like the fees have gone so much that everyone's convinced that they just need to go to hearing and take their chances that they may be able to recover if they're operating under a situation where case law or statutory law.
Welcome to podcast of New Way Home Care. Connecting is caring, where we connect hidden gems in our community, where we connect the resources in our community, and where we connect the stories from within our community. Today we have a wonderful guest with us, Honorable Retired Judge Ana Maria Luna. I'm going to call you Judge Luna. Is that okay?
That's fine.
Judge Luna, thank you. Thank you so much for coming on our show. I had to be honest and tell you this. You are the most prominent person to come on our podcast right now. So I'm really grateful to you for that.
Oh, so privileged to have the invitation. This is really something special for me.
Thank you. So if you want to share about...
Sure. Well, I grew up in the southeast portion of Los Angeles County, a city called Downey. I'm the oldest of 5 children. Went to Catholic school most of my life. Fun fact, I didn't go to 3rd grade. I skipped 3rd grade and headed off to public university, UC Irvine, because at the time I thought I wanted to be a doctor. I worked as a candy striper at Rancho Los Amigos Hospital. I also worked with the Catholic Church. We used to transport patients from their wards to the Catholic Church that operated on the Rancho Los Amigos property. And so I thought I wanted to go into medicine. So I started at UCI as a biology major and got 3 years into it till I hit biochem, and then a nice grad student said I should probably look for something else to do. It turns out that from the time I was age 14, I was working in a law office in Norwalk, across from the Norwalk courthouse, law office where my mother was the paralegal. So I really do owe my career to my mother. She was the toughest boss I ever had. This was in the days where you use carbon paper. My mother didn't like whiteout. So if I got a letter wrong, I had to start all over.
Oh, my goodness.
And so I remember very distinctly the letterhead coming back with red pens, circles on it.
Very disciplined.
Very disciplined and very exacting. And you know, fast forward, that's the way I have tried to be in issuing orders or issuing decisions, is to be exacting. And I have to harken back to those days working under my mother's supervision. So again, having worked in the law office since I was 14, started out as file clerk, then filled in as a legal secretary when during my summer vacations and when secretaries were on vacation, and then went to law school.
Which law school?
I went to USC.
USC. Nice.
USC. And the attorney who owned the firm was a big Trojan, and I had the opportunity at the last minute. I was a last minute admit to Berkeley. I had also been admitted to USC, and the gentleman who owned the firm, Charles Weldon, now passed on of blessed memory, just said, look, anything that's not covered by scholarship, I will handle. So, from a financial standpoint, and law school was not as expensive as it is now. I don't have to tell you what that costed.
Yes.
It was an offer, too good to pass up. So I ended up going to USC. And then I thought I would come back and work in that law office, but there were issues that the owner of the firm wanted to avoid. Not that it would have happened, but he wanted to avoid any sort of allegations of nepotism because my mother was still working there. So I just took myself down the hall in this Southeast Law Center and found a sole practitioner who was looking for an associate to practice family law. So my introduction to the courtroom, and for the first 7.5 years of my career, was in family law. And I practiced in that area.
Very stressful profession, right?
It's a very stressful profession. But when I looked at my peers coming out of USC, none of them were getting into the courtroom. They were in cubicles, they were writing pleadings, but they weren't in the courtroom. They weren't interacting with judges. They didn't have the opportunities to do jury trials. I was into a jury trial pretty early in my career, not in family law. It was a spillover criminal case from a family law client. So those opportunities came to me quickly, and certainly more quickly than my peers who were grinding out the billable hours, like I said, in some cubicle. And so I practiced in the area of family law for 7.5 years. I had married while I was in law school, had my son while I was in law school. The marriage did not hold. So 7.5 years into the marriage, I went through my own divorce. And the nice thing about being a lawyer, you can just jump to a different practice area. And so my joke was I went over to the public defender's office because therapeutically, it was good for me to cross-examine police officers. My ex-husband was a police officer, so therapeutically, it was good for me to have that experience, and also gave me immediate credibility with my clients because I started in Compton. So I'd walk into the lockup area and the guys behind the glass would say, "Oh, you don't know how cops lie." And my first marriage broke up because of infidelity. And I would just lean in and say, "How much time do you have?" And so anyways, just kind of immediate rapport. So I moved from the family law practice to criminal defense work. Again, a lot of experience in the courtroom, a lot of experience dealing with different judges, a lot of experience dealing with the field of evidence, being able to read people, particularly jurors and witnesses. And I was about 2.5 years as a public defender when I was asked by a judge in one of the municipal courts, because we were a smaller court system then. We had two levels. We had the municipal courts and we had the superior court. And I was asked to come in and serve as a commissioner at the municipal court that was located in Southgate, so neighboring to the city that I grew up.
That is a transition from being a practitioner to a judge.
Judge.
Okay.
I was selected as a commissioner. It's a totally different process now because we are just one court system, the Superior Court. But back in 1992, we were all these individual muni courts that would feed into a Superior Court. And I had known the judge and the judges in that area through my involvement in the local bar association. And so they had a retirement. They had never had a female bench officer in that part of the county. They'd never had anybody with a Latino or Hispanic surname, and it was a changing demographic. Some people may remember way back in the day, it would have been in the paper that the judges there that were all white males instituted an English-only rule in the clerk's office that got quite a bit of attention, not good attention. So kind of on the heels of that, there was retirement came up by somebody, and they just decided it might be time to, have a female there, have somebody that is of Hispanic or Latino background, would, be able to work and promote the idea of justice in the community.
So you were the first Hispanic Latino judge in LA County?
Not in LA County, in the Southeast area.
Southeast area.
So that would be the cities of Bell Gardens, Huntington Park, Vernon, Cudahy, Maywood. I'm sure I'm missing one there. But 7 cities there.
7 cities.
7 cities there, right.
That's a significant step.
Yeah, that was a significant step. 2 years later, there were a number of retirements, which led to something called open seats. I ended up running for an open seat. My opponent was a gentleman, an attorney who had run 2 years prior against an incumbent. The incumbent judge kept his seat, but only by 92 votes. So the gentleman who ran against him, he and I squared off for this open seat. I joked we should have just carpooled because we were always stumbling over each other at certain events because we were all trying to get out in front of, high propensity voters. But at the end of the day, I had a little crew of students that I was mentoring from the junior high that would come canvass the neighborhoods with me. And I remember on the day of the vote, we got out and we're knocking on doors. I'm on one side of the street in Southgate, these 2 middle schoolers on the other side, and I can hear them pleading, "We'll stay with your husband. You just need to go vote. We need you to vote for Commissioner Luna for judge." I just remember hearing that across, and I said to myself, boy, if I win by 1 vote, I know where that vote came from. As it turns out, I won by more than one vote and certainly more than 92 votes. So I came onto the bench then at that point instead of a commissioner selected by the judges.
So which year was that? 93?
92.
92. Okay.
So, I'm sorry, 94. 94. I came on as a commissioner in 92, ran in 94. And then the oath of office for that term was administered January of 1995.
95. And for how long once you're
Once the judges elected, the term is for 6 years.
6 years.
Yeah. And then you stand for re-election. So a lot of judges will never appear on the ballot because they come up, they file their papers, they pay their filing fees. They're not challenged, and so they're deemed elected. So the voters never see their names on the ballot. It's only if there's an open seat and people are running or a judge is challenged.
So you have been a judge for close to 30 years.
A little over 30.
A little over 30 years.
Yeah. Mm-hmm.
So what has been your experience as a judge? I mean, now you're on the other side of the...
you move from the role of being an advocate to being a neutral.
Neutral.
It's a different skill set. It's something that I think if you're a good judge, you're always trying to refine those skills. I don't think if you're a good judge, you don't get comfortable with where you're at. You certainly find ways, especially if you move into more complicated areas, complicated civil cases, complicated divorce cases, probate and trust litigation. You learn to refine your skills and ways to make your day-to-day a little bit easier by having the attorneys work, as I call it, MAW, make attorneys work principle. And so, at the end of my career, I learned to get the closing briefs in Word format so that when I'm putting together my decision, I can cut and paste what I like in terms of summary of somebody's testimony or summary of the law. And put it into my statement of decision, and then tweak it around a little bit to have kind of the flair, the fate, or the wording that I wanted to see in the final product. But it was just, again, learning over the years, over 30 years, how to make it easier instead of starting from scratch and saying, okay, now I've got to write this decision. Those are things I think that...
How many different departments were you?
Oh, wow. So I started in criminal. I started in Southgate Huntington Park. I went downtown in the late 90s and did family law for a time out of this Moss courthouse. And then there was a drug treatment initiative that passed in 2000, took effect 2001, which I remember because I was pregnant with my daughter who's now in law school. And I was asked to chair a task force to implement this drug treatment program or initiative countywide. So they pulled me back out of family law, back to the Southeast area. And at this point, they were starting to close down or consolidate for budgetary reasons and other things on the courthouses. So I was in Southgate for a time and then shifted over to the Downey courthouse. So I'm really in the backyard of where I grew up. And right on the Rancho Los Amigos property where I used to be a candy striper, yes.
Right.
And I was in Downey. I was actually the site judge. So, it's a smaller courthouse, 7 courtrooms. When you're a site judge, it's like being principal of the building because you're responsible for coverage if somebody calls out sick or a facilities issue, working with your court administrator to get that addressed, helping celebrate the staff for Employee Recognition Day, all the things that, a principal of a high school or a school would do is kind of the idea of a site judge. And I was there, I think, in that capacity over 10 years. And then I was approached by the supervising judge, the then supervising judge of family law, to see if I was interested in coming back to family law, but going to Long Beach instead of downtown. And I was ready for a change. And so I moved to Long Beach and started back in a family law calendar and stayed in Long Beach 2014 to 2019. At which point I orchestrated what I called the mommy swap. My daughter, I wanted to stay close to home because my husband had passed away. And in 2012, he unfortunately had a form of dementia, frontal temporal dementia. But we were able to keep him at home. So
that's one of the hardest form of dementia.
It is. Many a support group I attended at UCI covering that.
We had quite a few clients with frontal temporal dementia. And we have seen that is the most challenging not just for us professionals, for the family is the hardest.
Yes, it is. It is hard. Just as an aside, so there's two variants of it. At least that's my understanding, at least at the time I was dealing with it. One where they have a behavioral variant. That'll be the person that's calm when you take them into the restaurant, but all of a sudden is taking their food and turning it upside down on the table. That was not, thankfully, my late husband. He had the variant that erased speech, which was probably more painful because he was a lawyer. He studied Torah, he studied Plato, he studied Socrates, all in the morning before he started working his cases. So for somebody that was so tied to reading and the written word, his brain was erasing words. So at the end of his life, if you asked him, what's a dog, he would just look down and point at our dog and say Chica, which was the dog's name. He couldn't explain any more than that. I truly believe he realized that he had slipped, and that was probably the most distressing thing to him at the end. But in any case, he had passed in 2012. My daughter was going off to USC in 2019. There was another mother, a new judge with young children in family law downtown who wanted to get to Long Beach because that was home base for her. So I orchestrated the mommy swap. I would go downtown because I wanted to get downtown and she could be closer to home. So I came downtown in August, September of 2019 and was in family law for a very short time a very short time in that courthouse, the Mosque courthouse, when I was offered the assignment in probate. So I came into the probate department right about the time of the pandemic shutdown. So my introduction to probate was very slow because, again, any of the disciplines, we were only taking in emergency cases, which for probate meant temporary guardianships and conservatorships. Everything else was being put off or continued. And of course, once the restrictions were lifted and we started opening up, that led to a very crushing caseload and a lot of trial by fire to get up the learning curve. A very interesting but very rule-oriented and detail-oriented area of the law.
Judge, I've known you for several years now and seen you at so many of these conferences. Everywhere I have seen people really look up to you and respect you for your knowledge and for your opinion. Which of the departments that you have been responsible for has been the hardest for you?
Oh, the hardest. The hardest has to be family law, that assignment, because there's so little resources put to it. And that's been the case all my career. I heard judges and practitioners when I was a family law practitioner saying, the family law department's the redheaded stepchild. They never get the resources. Supervising judges of that discipline have tried over the years to bring more resources, and they have succeeded in some ways. But when you compare it to other divisions that work with children, you just don't have the same amount of resources. So at the end of the day, you're really just relying on the power of the witness stand and the ability to question witnesses and making the decision about who gets custody and what that custody looks like and what the timeshare looks like, and hope that you get it right.
And there's children involved all the time.
Yes.
And that makes it harder too.
Makes it very hard. That's not to say that you don't deal with people in the probate department, because again, we have conservatorships. So you have a disabled adult, an elder who is vulnerable, but now you've got an attorney that's appointed for that person. You've got the probate investigator. You've got probate attorneys looking at the pleadings saying, this looks right. This I hasn't been dotted. This T hasn't been crossed. So you've got a bunch of I's on the file before you actually have to make a decision on it. So, in some ways you're able to kind of craft and think about and how you want to manage this case and what orders you want to make based on the information that's been provided to you from other sources.
Judge, after 30 plus years being in the bench, what made you transition from bench to mediation, especially in family-related disputes?
Candidly, I thought it was time to leave the bench, open up opportunities for other judges who wanted to come into probate to have that opportunity. It's one of the smaller departments or divisions of the court. I think we were 11 at the time. I think there's 2 more that have come on, so maybe 13 now. I thought it was time to kind of pass the baton on. Frankly, I could have gone 2 ways. I could have gone as an assigned judge and just be like a substitute teacher and just fill in up and down the state, in various settings. But when I talk to my colleagues who had left the bench and gone into mediation, they talk about really being able to roll your sleeves up and work a case, kind of get the backstory on things. And, maybe that makes me a little voyeuristic, but I like getting the backstory. As a judge, you may have a hint of the backstory, but, evidentiary objections, prevent the whole story coming in. So here you have a chance to talk to the parties, to kind of see where the dynamics lie, sometimes where the hostilities lie. I backed away from the idea that, if you do a settlement conference on the bench or you do a mediation, that you're going to have a kumbaya moment and everyone's going to come together at Thanksgiving or over the Passover Seder and all be happy. I abandoned that idea a long time ago. But for me, if I can, in mediation, be the pressure cooker that lets the steam come out a little bit, brings the temperature down, allows people to kind of think a little more rationally about how they can take the off-ramp from litigation and an evidentiary hearing to just get their lives going. It may not be 100% of what they thought they were going to get when they started, but they get something that they can live with and that they can move on with their lives. And so that is probably what the attraction was the ability to be more fully participatory, being able to get the full story from people, being able, and in this world, for the high net asset cases, really seeing how tax laws and movements of properties or assets allows for generational wealth to be developed.
And Judge, families often don't realize how time consuming and expensive the litigation can be. What does it actually look like in real cases?
I make sure, and again, I've only been doing mediation since July, and I'm actually presenting to the Los Angeles County Bar in a one-day presentation on litigation this coming Saturday, and my particular panel is on settlement and mediation. I mean, one of the things I'm going to tell the lawyers is that make sure you know how much you've incurred or you've charged in fees, how much you've been paid, so I can use those numbers as I go between the rooms. Because generally in this area of litigation, there's an estate or there's a trust that is paying for mediation and paying at least for a period of time, the trustee fees, the trustee attorney's fees, the personal administrator's fees, the personal administrator attorney's fees. If we've got court-appointed counsel involved, they can be billing at the private rate set by the court. It all starts draining at what is available at the end of the day. So my clearest example is a case that I did 2 evidentiary hearings on. I understand that before I came into the case, the family, the mom was the last person to pass on, but when she passed on, there was a lovely house in a very nice area of LA, a strip mall, I believe, up in the Glendale Burbank area, and then 2 pieces of property along the Alameda corridor. One they referred to as Big Alameda and one they referred to as Little Alameda. So, kind of a nice real estate heavy, but still, a nice estate to have accumulated, mom and dad. So by the time I get involved in the case, the house has already been sold to manage the cost of the litigation and maintaining the estate. Yeah. The strip mall had been sold. They were just in the process of selling Little Alameda. So really, as I'm hearing the case, the only thing left was Big Alameda. And when I left, they were still fighting about whether they were going to sell it or try and buy it, I guess, or buy each other's interest out. It was one of those moments where I'm thinking, these parents are just flipping in their graves at everything that they worked so hard for to leave behind. That's all gone to the lawyers.
I know, it's so hard to see that.
And it's very hard to see that. And it was, a sister and a brother against another sister. It's just very hard to see that. So I, in response to your question, I approach it not necessarily hitting people over the head with the numbers to start with. I want to see, I have pre-mediation calls. I had a bunch yesterday in preparation for one tomorrow, where I just want to see what the temperature in the room is and to ask them to describe their relationship either with the parties in the other room that they disagree with, or with their parents. If they were disinherited or they were getting less, why did they think that was? How do they feel about it? Just kind of really push and delve into that so I can see, number one, what the divide is, what we would call the delta between the positions, and then look for creative ways to maybe bridge that gap. Because again, in mediation, you can go outside the estate planning documents if that's what's at issue to craft a solution. And you can say, okay, well, what about, the settlor's intent or the decedent's intent, mom's intent, dad's intent, grandma's intent. You want to honor that. A probate judge certainly needs to honor that if this was litigated. But when you're in mediation, you have to factor honoring that intent with how much is it going to cost to do that if you can't get the litigation to stop. And that's kind of the message or the walk that I do between the rooms, is to try and say, okay, you can stick to the script as it was written by the testator or the settlor, but what are you going to have at the end of the day? And did your parent, did your grandparent, did your aunt, did your uncle, the family friend, whoever it was that left the estate behind, did they really intend for the monies to go to the lawyers? Yeah. So let's just talk about it.
And with mediation, you're always the adult in the room.
Yes. Well, yeah. And or that you've got adults in other rooms, and they may not initially want to give in because they feel like they're giving in to a sibling that's always been failure to launch or always been one that kind of mooched off, the parent or the grandparent. It's hard to let go of not wanting to further enable that individual. And so, depending on what I've heard, sometimes I've used the line, but this is the child that your mom or your dad or your parents created, so.
It is. It's so true.
So how do you expect that person to change now? And what can we do to get you out, to get you the most that you can out of this estate or out of this trust, and let you go on and have the life that you want to live? You can't worry about what they do with their money.
Yeah,
okay. If they're ones that are always going to spend money, they're always going to spend money. You can't worry about that.
You can't control that.
I can't control that.
So, Judge, what role does mediation play in the California courts today? Is it encouraged? Is it required? Or do you think it is underused?
Well, probate is one of the areas where the court has a lot of flexibility, or I shouldn't say flexibility, has a lot of power to order it. We have Probate Code Section 17206, which is kind of a full plenary source of authority in trust actions, not necessarily estates or conservatorships, although judges will lean into that power in those other settings. But certainly in trust, allows the trial judge to order parties out to mediation. So it is an important part of the process. It is a tool in the toolbox. And then we have this case that the practitioners either love or hate, or Breslin, which means that if notice of a mediation is given and a party chooses not to participate and there's a settlement, the case can be settled around that individual, and the court can approve that settlement over the objections at the hearing on the petition to approve of the non-participating party or entities. In Breslin, it happened to be charities that didn't show up for a mediation and that did not recover anything out of the estate. And that whole system was upheld through this decision in Breslin. So I've done a few mediations with some charities. Charities don't necessarily like Breslin because, there may be reasons that charities don't participate. They don't have the resources to have an attorney on retainer. They may want to sit by the sidelines and see what happens. And then they come in too late, as the charities did in Breslin. But, for me, having sat on the bench, I thought it was a wonderful tool to use. I was probably a judge, and I'm speaking based on having lectured and educated judges statewide. I'm a judge that probably wouldn't send people to mediation right out of the gate because I think the information gap can be too much. I think people need to feel two things. Number one, that if they brought the litigation, that they had the chance to do what litigation allows you to do, discovery, request for production of documents or interrogatories or a deposition or two, kind of have that experience. And at the same time, I want them to feel the pain of the attorney fees that go along with that. So you can see if you've done some limited discovery and all of a sudden you're $100,000 into attorney fees, I think that's going to be an added, an expectation readjustment that's going to occur. And that's probably the best time to have your mediation, not too early. Okay. And sometimes it's too late. Like the fees have gone so much that everyone's convinced that they just need to go to hearing and take their chances that they may be able to recover if they're operating under a situation where case law or statutory law allows them to recover the fees.
So to experience that pain point, only then, the mediation is going to be productive.
Correct.
Yeah. Okay.
And there's ways to make it productive. One of the first mediations I had was actually a private fiduciary, so really didn't have a dog in the fight, just couldn't get the two individuals to agree on what percentage the decedent's estate should be divided. And then it was a situation where it's a surviving sister, and it turns out a woman who was adopted as an adult by the deceased sister. And it just occurred to me that the surviving sister, had no idea what the nature of the relationship between the woman who was adopted and her sister. They were divided by geography. Surviving sister was in California. The decedent died, I think, in Kentucky or Tennessee, one of those states. And so in my pre-mediation, talking to the woman who had been adopted by the deceased sister, I said, do you have like photos? Like, did you put together just a little PowerPoint for me? And so she did. And so I held that. And then at some point, with her permission, the adopted daughter, I said, I'm going to show this to the other room. And I was doing this by Zoom. And it was really powerful because the woman did not appreciate how bad her sister had become physically until you looked at it. And then you see her in, the deceased sister lived in a care home, but she was brought home by this woman that she adopted. So you've got photos of her with, in a home with family surrounding her, birthday cakes, things like that. And so kind of the light went on a little bit with the surviving sister that, wow, someone really was there and took care of my sister.
Yeah.
So then she could be, more willing to, give up or agree to a disbursement of the monies that everyone could live with. But for her having that glimpse into what was going on with her sister and the joy that this woman had brought into her sister's life might not have happened. So, and those are things, you can't really do as a judge, but, you have those opportunities in mediation.
Yeah. Just in your experience, what are the most common conflicts between the siblings or, let's say, disputing parties when it comes to situations like this? I'm smiling because I was raised Catholic and then converted to Judaism when I met and then married my second husband. So my favorite book of the Bible is always Genesis, where families are always doing terrible things to each other, right? Stealing birthrights or throwing somebody in a pit and leaving them to die. It was all the family dynamics. So, things don't go away. That's why we have the popularity of shows like Knives Out, movies like Knives Out or Succession, or if you even watch House of Guinness, the funny one that's on TV, it's called Fisk, and it actually profiles a small trust and estates firm in Australia. But jealousy and greed and mommy always loved you best or loved me best or daddy, I'm daddy's girl, and all those dynamics. Who got the biggest scoop of ice cream?
Yeah. I had an extern who is going into planning. And so I had her watch a trial where the estate documents on a high net worth estate have been crafted by a well-recognized estate planning practitioner. And we had we had taken into evidence, or I took into evidence, the careful notes of the estate planning attorney, the date, who was there, who initiated it, what was discussed. Very careful notes.
Mm-hmm.
And so I showed this to this extern. She was out of USC Law School. And she's looking at me and she says, she did everything right. Why are we here? I said, have you listened to the two brothers? And these are men in their early 60s. She says, what do you mean? I said, did you hear the one brother testify how the other brother put a chain around the tire of his car to prevent the other brother from moving it when they were 17? I said, there are things
always goes back.
There are things that you are not going to be able to plan around because there's just these family dynamics. However it comes about, there's the jealousy, the resentment. Maybe, someone resents a sibling that did really well and you did not do so well. You didn't do so well in your career. You didn't marry as well. Your sibling did. And that person is still getting an equal share to you. It's fascinating. All the reasons why people fight in probate, in trust and estates matters. But it really just comes down to like where they were as kids, So, in my mind, I can see them, fighting around the Christmas tree or fighting around the Shabbat table or, any sort of family celebration that you want to conjure up.
It's just the small things they never got a closure on.
They never got a closure on, and they may not. So, in trying to get a case resolved, it's really focusing on you can keep this battle going. And you will have nothing at the end of it. And how does that honor your parents and what they tried to leave behind? How does that honor your grandparents who, was trying to pass down this generational wealth, or whoever the source was? How do you honor that person's memory? And so, you're trying to always kind of refocus and bring people into that. But, I'm always aware of that undercurrent of whatever it is, the jealousy, the insecurity, if that's the failure to launch person. You've got, and I'm sure you've seen this, siblings that I would call are like the Excel spreadsheet siblings, and they've got it all detailed out and they got the numbers. And then you've got the other one that's the yada, yada, yada sibling with the shoebox of receipts. You've just got these two different personalities. And maybe it's the parents left the yada, yada, yada as the trustee. And this one, the spreadsheet is just like going crazy because they can't get anything and they can't get it in an organized fashion. So, it's looking at those dynamics and saying, okay, what can we do to get you where you need to be? If you've got enough of an estate, you can bring in a private fiduciary to kind of just take everything into control and let them stop focusing on each other and just start focusing on what the PPF is recommending with the cost that the PPF adds to the trust or the estate administration. So, it's all those things that you're looking at and trying to find a way to tamp down so that you can get the conflict done and over with. And for me personally, having just come off the bench, I feel like I'm clearing dishes for some of my colleagues that are still there. That brings me the most joy is knowing they don't have to deal with the case.
Yeah. So just when you bring your family into mediation, what's the first thing that you try to accomplish?
I try to establish a rapport and confidence and trust between them and me. Sometimes I can do that on a pre-mediation phone call if the person's are self-represented. And I think what we're going to start to see in an age of AI is more self-represented litigants who I will affectionately refer to as EOEs, experts on everything. If they can go in and do a search and AI up a petition, why do I need a lawyer? Okay. That makes it interesting for the judge having to deal with a self-represented litigant and getting them to clear their notes, but they're probate notes. So let's assume that they can get their pleadings up to snuff to stay alive in the court. And then moving to mediation. Some mediators don't want to deal with self-represented litigants. I have been and will continue to do so for the foreseeable future. But I do think that with the advent of AI, we will probably see more self-represented litigants, filing objections to petitions or accountings and things like that, and then being ordered to participate in mediation. So what I want to do with those folks, and certainly with the clients of represented individuals who have a legal representation. I want to have the conversation with them. I want to let them know what my background is, let them know what the confidentiality provisions of mediation, that it's a highly confidential process. I can't be called out, sit for a deposition or to a witness stand to talk about what happened in mediation. Neither can any of the parties. The lawyers can't mention what happened in mediation. Mm-hmm. And that's because you want to have frank and full discussion to see if you can get to a settlement or resolution of the case. And that if you have information that you want to have me keep confidential, I will keep it confidential. I will hold those cards close to my chest. However, if I go through the day and it seems like it would be helpful to share some or all of that confidential information, I'm going to circle back to you and say, hey, can I have permission to share X or share X, Y, and Z? Mm-hmm. And, the litigant can say, and the attorneys can say yes or no. I try to let them know who I am in terms of expertise and what I bring to bear in terms of perspective. I don't come out evaluative of the case right away. I really don't become evaluative of the case until I'm asked to do so. When you're in a room and someone's giving a position, they're giving their demand or their offer. Well, all right, tell me how you want me to justify that when I take this into the other room, and vice versa. So the mediation process, and I didn't believe it when I heard it before I retired. Oh, you don't get to a number, even start talking numbers till 2 or 3 in the afternoon, and you started at 9. And I didn't believe that could be the case, but that is the case because you're spending the time developing the rapport, letting people tell their story. Then, and depending on how many people you're dealing with, you could have more than 2 rooms going at any time. You could have a couple people. You have people live there, and you have people in in Zoom that you're having to go into a Zoom room and deal with. But you're really trying to let people say enough and give you enough information. And I take a lot of notes, which is probably the biggest criticism people that have watched me mediate have of me, is that I don't look at people in the eye long enough because I'm taking notes. And that's always been my way as a judge, as I would listen, but not look at the people in front of me or look at the screen. I'm taking notes because in my head, it's my process, my way of being able to craft an order. So now it's my way of being able to kind of craft a solution is to take the notes. So if anybody, mediates with me and thinks I don't look them in the eye, I apologize in advance. It's not that I ignore you. I really am paying attention because I really want to get, to terms or deal points that I think will carry the day.
Yes, if you could give one piece of advice to the adult children who are navigating care for their parents, what would that be? Sort
of the same advice I would give parents in custody disputes is you need to love your child. So in your example, you need to love your parent more than you hate the other. So in the case of divorce, you need to love your child more than you hate your ex. Here, it would be you need to love your parent more than you hate or despise your sibling or their new spouse. Because again, and especially in conservatorships, blended families, it's often the case that you've got children from a prior marriage, not at all on the same page with the new spouse. And, sometimes for good reasons. Sometimes the new spouse is, as they say, the evil stepmother. And that's kind of a line I use. I said, what fairy tales did you have read to you where there was ever a nice stepmother? They're all evil stepmothers. And I say stepmothers because just typically the women tend to outlive the men. So it's a second spouse. It's a wife that's involved. You have to let go of whatever is going on with the sibling or the step parent or whoever it is on the other side that you disagree with. Because again, if you love that parent, you want their last years, months, weeks, days, not to feel like they're caught in the crossfire. And, the person that's got dementia, what do they know? Maybe they're not able to articulate it, but do you believe at some point they can't feel vibes in the room? I think they can. And so, why would you want to make things more distressful? And, if you're in litigation on the back end after the person passes away, do you really want to have used up any goodwill with the other side during the lifetime of someone that you both claim to love so much?
Great advice, Judge.
Thank you.
Before we close, Judge, we want to talk about how one can reach you if they need your services at signature resolution?
Yeah, if you have any sort of case, I'm assuming you would have an attorney involved, and you don't necessarily have to have a case filed to do mediations. There's certainly opportunities to have pre-filing mediations. So just have your attorney reach out to Signature Resolution in Los Angeles. It's easy enough to Google, and I'm sure we'll find a way to give my contact information on any clip or final production of this video. But Signature Resolution in Los Angeles, we have offices actually up and down the state, but the downtown Los Angeles office is the mothership, so you can reach out there to find me. But thank you very much, Sam.
Thank you, Josh. This has been so wonderful.
Oh, thanks.
I had been wanting to have you on our podcast for a long time, and you made it happen today. Thank you so much for that.
All right. Glad we made it happen. It was a long time in the making.
I know.
Thank you.